If your ex served you with a restraining order and you have kids, this video is for you, because in this video, I'm going to be explaining exactly how to deal with custody in a restraining order hearing if you are representing yourself. My name is Veronica. I am a domestic violence restraining order hearing defense attorney, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you everything that you need to know in order to have the best possible chance at winning your restraining order hearing. If that's something you're interested in, you can find your first free class down below. Recently, I was at the Stanley Moss Courthouse in downtown Los Angeles in the family law clerk's office, and I overheard a conversation between two women. One woman was complaining that her ex doesn't pay her enough child support. The other lady told her, well, why don't you just file a restraining order? You can go down to the clinic here, they'll help you file one. If you win the restraining order, then you'll probably get 100% custody, or at least close to it, and then he's going to have to pay you more child support. If that makes your blood boil, you're in good company. You're at least in company with me. And this video is dedicated to those two ladies. So let's jump right into it. Okay, something that you may not know, when you're served with a temporary restraining order and it says on there, it lists your children's names and ages, and it says that you can't see them until the hearing. You may be thinking, okay, well, I need to win this entire restraining order hearing, otherwise I won't be able to see my kids for, in California, up to 5 years. That's actually not how it works. So in California, if there is no restraining order, then the default is 50-50 joint custody, or at least close to it. And it can be very difficult for one party to get more than 50% of the custody. But there's a big exception to that, and the exception is that if a restraining order, a domestic violence restraining order, is granted against one of the parties, if the court makes a finding that domestic violence occurred, then there's what's called a rebuttable presumption that it's not in the best interest of the children to be with the abuser, with the person who has been found to be abusive. Now, the key word there, and it is kind of legalese, is rebuttable. So if something is rebuttable, that means that you can rebut it, you can refute it, you can show your side of the story to get rid of that presumption, to defeat that presumption, right? So how do you do that at a restraining order hearing? The big mistake that a lot of people make is that they go to the restraining order hearing maybe prepared to show that they weren't abusive, but they are not prepared to address custody. So if they lose the restraining order hearing, obviously they hope that that doesn't happen. I hope that that doesn't happen to you. But if it does, you still get a chance to show the judge, okay, even though you issued a restraining order against me as to my ex, I still am a good parent and the kids need me, and it is in their best interest to still have me in their lives and for us to still have 50-50 custody or very close to that. So you want to make sure that any evidence that you have of that you bring with you to your hearing. If you have any witnesses who have seen that you are a great parent, make sure you bring that to your hearing. If you're really involved with the kids' schools and their teachers are willing to write you a letter talking about what an involved parent you are, make sure that you bring that. Now, what is the judge looking for when the judge is trying to figure out if it is in the children's best interest to be with you? In California, they're going to be looking at the child's age, health considerations, emotional well-being, the relationship with each parent. They're going to be looking at the kid's school schedule, extracurricular schedule, the parent's ability to provide basic needs for the children, and the living arrangement. And when I say living arrangement, I mean, for example, does the kid have their own bedroom in one house but not the other, for example? That can be something big. So you want to make sure that you address all of those things as much as is relevant. Like, how do you make the kids' lives better? How are you a good parent? Bring proof of that. Bring pictures of you with the kids doing outings. Now, exactly how do you do this during your hearing? Well, so there are two ways that the judge might deal with this. First, the judge might want to hear all the evidence regarding the restraining order and whether abuse occurred first, and then address custody. Because if there is no restraining order granted, there's no point in hearing everything about custody. So if the judge is busy, they may want to do this. So how do you bring this up in front of the judge? How do you figure that out? So in the course that I created, I actually give you a template on exactly what to say to the judge. Now, this is just an example, but this should give you a better idea of how you are supposed to bring it up. Okay, so at the hearing, first the petitioner goes, they present their case, then you get a chance to present yours. And at that point, you might not know, the judge might not have said anything about whether you're supposed to bring up custody or not. So I suggest asking, and here's how to do it. You would say, If this court is inclined to issue a restraining order, I would ask to be heard regarding the best interests of our child or our children, and then wait and see what the court says. So what you've just done by saying that is you're telling the judge, if you are leaning towards granting the restraining order, then let me present you with all of the evidence that I have as to why it is in the best interest of the children to still be with me and for me to have custody. The judge might say no. If the judge says no, then you know you're probably going to win the hearing because the judge is going to have to give you the opportunity. If the judge says yes, then that is your opportunity to present proof that you, for example, take the kids to all of their medical appointments, to present your photographs, to explain all of that to the judge. Now, let's say that the absolute worst case scenario happens. You lose the restraining order hearing, and then in addition to that, the judge also says that it's not in the best interest of the children to be in your custody. What you need to do is you're going to see that the restraining order will last between generally like 1 and 5 years. That doesn't mean that the custody order that the judge makes is going to be in place for that entire time. If that happens, listen carefully to what the judge says. The judge may give you some clues on what they want to see before they're going to change the custody order. For example, if the judge has a problem with the living situation, I mentioned before, one of the things that they might be looking for is, does the child have their own bedroom? Okay, then you know that you're going to have to change that, and you're going to have to make sure that you do change the children's living situation. If there's a problem getting the child to and from school and their extracurriculars because of where you live and it's a really long car ride, then you're going to have to make those changes. If the judge doesn't give you any clues but has found that there was domestic violence, did grant the restraining order, then I would suggest taking domestic violence classes or going to counseling. You might also want to take some parenting classes. Once you have maybe at least 3 months of those under your belt where you're going at least once a week, you can always come back into the court and tell the court that there has been a change of circumstances because you have now done all of these classes, you've done all of these things to improve the things that the court was concerned about, and ask the judge to change the custody order. There'll be a hearing, you'll have to file a request for order, but don't give up. I hope that you found this video helpful, and look, if you do have a restraining order hearing coming up, you can keep binge watching YouTube, hoping to find the answers, or you can just get them served up to you on a silver platter. So I would encourage you to at least go and take the free class, see if this is something that you think would help you. I think it would help you. Click on the link down below and you can get your free class there. And if you did find it helpful, please don't forget to subscribe, like, and ring the bell.